Hi, I'm Alexia Russell and this is The Detail. Everyone agrees we all need to pay our fair share of taxes. And everyone knows big tech companies don't.
Problem is, of course, the so-called lack of tax that is paid here is not illegal. It's not like we're chasing crooks, companies who operate anywhere they want. They operate in places where tax is low, and tax is low in a lot of places, and that's not illegal either.
I mean, do we just need to accept that, look, we'd all love to tax Google and Facebook, but probably just never will be able to?
The UK-based Fair Tax Foundation says the big American tech firms known as the Silicon Six have paid almost 470 billion NZ dollars less in corporate income tax in the past decade compared with US companies making the same profits. We're talking about Amazon, Meta, Alphabet, Netflix, Apple and Microsoft, which between them have generated $18 trillion of revenue and $4.2 trillion of profits over the past 10 years. The companies, says the foundation, have hardwired tax avoidance into their business models. New Zealand did have a digital service tax on the books that would have captured 3% of the incredible profits these companies make. That's gone.
I took a look at this tax. We've been looking at it a bit, and it's got some real drawbacks, and we've made the decision to pull it from the agenda.
It's estimated that the tax would have brought in $100 million a year, but the Revenue Minister, Simon Watts, decided it wasn't really worth it. There was a general agreement that you couldn't blame the government for doing that. US President Donald Trump's threatened retaliation, just as he has with every country that's tried to nail these elusive mega corporations.
Economically, we have such power over Canada. I'd rather not use it, but they did something with our tech companies today trying to copy Europe. You know, they copied Europe. It's not going to work out well for Europe either, and it's not going to work out well for Canada. They were foolish to do it. They put a tax on companies that were American companies that they shouldn't, a very severe tax.
The thing is that to tax these companies, we'd have to see their books, and most of them would rather keep as much information as possible about themselves under wraps.
I think that's right. I think there is an issue of transparency and lack of information.
They're providing the minimum information required under the law.
Even when they make public announcements like Amazon's much vaunted data centre expansion, and even when the Prime Minister hypes them up, the details can be clouded.
AWS, which is their web services, they do all the cloud storages, data centres and all that stuff. They're investing $7.5 billion in New Zealand. That will have an impact on our GDP for sure, create up to about 1,000 jobs, and it's about almost an $11 billion boost to our GDP.
But these big digital companies try and string us along and effectively mislead us.
But what we learned yesterday was, in fact, they haven't invested in building these new data centres. Instead, it appears, because they won't say much, but it appears they've just dropped their own server racks into other people's data centres around Auckland. And bear in mind, there are 21 data centres around Auckland already. So Amazon's about the only company that doesn't have a data centre in Auckland.
This issue of mega tech companies getting away with unbelievably low tax payments is not a new one. The Detail in 2021 looked at ideas being floated to force them to pay more.
Google, Facebook, Amazon, these companies rake in tens of millions, in some cases hundreds of millions, in advertising revenue every year, but pay very little in tax. Now, lots of countries have tried lots of plans to change that with varying levels of success.
None of those ideas were slam dunks, and when they did work, the companies found ways to get around the new laws. Here are some numbers. Google took in $1.1 billion in revenue in this country in 2024, but paid upwards of $1 billion of it to its parent company in Singapore as a service fee. That's more than 90% of its earnings. It paid just under $4.4 million in tax in New Zealand on what remained. If that service fee was relabelled as a royalty for using Google's intellectual property, which is probably what most of it really is, we'd get 5% of it. We can't know what that would work out to, but safe to say it would be worth chasing. Facebook is similar. 94.5% of its revenue is sent to Meta Platforms Ireland Limited for the purchase of services. Of its $167 million in earnings in New Zealand, government coffers saw just $1.3 million of it. Amazon Web Services NZ, in spite of bringing in $385 million here, had a loss on paper after it paid 80% of its earnings as a cloud service fee to its parent company. It paid $1.7 million in tax. But a new report from Tax Justice Aotearoa not only reports on the size of tax minimisation in the technology sector, but suggests a way of shaking that piggy bank using existing rules that the companies and the US have already agreed to. Nick Miller wrote the report.
I'm a former Inland Revenue official, also was a international tax specialist with HMRC back in the day. And recently I've been working with Tax Justice Aotearoa to look at the technology sector and in particular how companies minimise their tax here in New Zealand. And more than that, the report is looking at ways in which we could possibly challenge those arrangements using existing laws.
What is the overall issue with these massive tech companies?
These massive tech companies have a variety of ways in which they can minimise their tax. And we talk about three of these models in the report. The first is, and probably the best known, is the fact that they report revenue in New Zealand and then pay away up to 95% of that in some cases as a so-called service fee to either an overseas affiliate or their parent. Another way is to simply inflate licence fees so that they leave very little profit in New Zealand. Licence fees, for example, for software distribution rights. And the third way is that they don't even report the revenue in New Zealand at all, and they simply provide a service to their overseas parent for which they get a very small, very modest markup on costs. So there's more than one way that they do it, but most of the companies in the sector do it to some extent.
So let's get this clear from the start. Nothing they're doing is criminal.
It's not criminal. Tax law is nuanced, but the fact is that payments of this type can be mischaracterised, misdescribed, and if they are, then that can have taxation consequences. To give you an example, if you have a service fee paid away, something called a service fee that's simply taken as a tax deduction, that is, you deduct it against your profits. If that in reality is partly or wholly for intellectual property rights, then that's a royalty. And under our existing laws, then there should be some withholding tax on that. That's tax that we keep in New Zealand when that payment goes overseas.
But who decides if they're mischaracterised?
Misdescribed, mischaracterised. To some extent, that is a question of fact and evidence that I think is why you need to go into some detail into the circumstances surrounding these payments to actually determine whether they are in fact misdescribed or mischaracterised. And ultimately, it's probably something that only the courts will be able to decide.
So basically what we're saying is it's like having a company, you got a farm and you deduct the cost of your tractor and your fertiliser from it, and then the rest's your profit. They're deducting the cost of this massive service fee that they shift offshore to their parent company and saying, oh, no, that you can just tax us on what's left, the crumbs.
Exactly, yes. So it leaves very little left in New Zealand. And the question is, what is that service fee for? Is it really for services, or is it something else, like at least partly a payment for intellectual property rights, given that these companies, intangibles, intellectual property really drive these businesses in a way that you don't see in other sectors.
Right, so this is particularly pertaining to tech companies because of the digital way in which they operate.
Correct, yes. If you look at, for example, a company like Google or Facebook for that matter, it's their intangibles, the algorithms, the technology, the knowledge that underpins their business model, which is key to their profits, and that's intellectual property.
Is this difficulty arisen because our tax laws are not up to play with the digital environment, or because they're just clever at getting around them?
Our conclusion in the report is that we do still have existing laws which could potentially challenge these types of arrangements, because these service fees could potentially be described as royalties, and therefore there's already a very well-established, long-established set of taxation principles which say that if you pay a royalty, then you can withhold tax from that payment and keep it in the country that's paying the royalty, that is New Zealand in this case. So there are existing laws. Obviously, we were looking, like many other countries, at the digital services tax over the last few years, and that was specifically aimed at digital companies taking 2 or 3%, depending on the country, of revenues. And that's fallen by the wayside because of pressure from the current US administration and to some extent the previous administration as well.
That's basically fear of retaliation from the headquarters in which these companies are domiciled.
That, I think, is unarguable, that's why the digital services tax has been dropped, in particular more recently because of the threat of tariffs from the current US administration. Our view is using existing laws, the laws I was talking about just a minute ago about the long-established principles of source taxation, could, at least in theory, be less vulnerable to that kind of retaliation, because we're not saying we are aiming this specifically at the digital sector. What we're saying is we have existing laws which may apply to some of these arrangements used by companies in the technology sector, but of course they could be used in other sectors as well. It's not specifically aimed at the digital sector.
Yes, but I presume that if IR suddenly said to these companies, that's royalties, hand over the withholding tax, and, let's look at your accounts for the last few years as well, that would end up in court, right?
It's likely that it would end up in court. What is quite noticeable about taxation of multinationals in New Zealand is how few cases have been litigated. I mean, I can't really think of many over the last decade or so. Whether you look in Australia, there's been a lot of litigation. So that might imply a reluctance to test the law. It might suggest a lack of resource. I'd be speculating, but the fact is there hasn't been a lot of opportunity for New Zealand courts to opine on this in the past.
Are you saying that, we have to do something about what's going on now?
Yes, I think if we simply acquiesce, I mean, what are we expecting to happen? That these companies will become more emboldened to push the envelope, potentially more. So, I mean, doing nothing is not really an option. We potentially lost, through not having the digital services tax, 130 million anyway. So, I mean, that's a significant loss of revenue over a period of time. So, yeah, I think we are just possibly encouraging them to do their worst if we simply don't challenge it and say, well, that's fine. These companies are very profitable, and asking them to pay a reasonable amount of tax does not seem onerous in the slightest.
Craig Elliff is a professor of tax law at the Auckland Law School and director of the New Zealand Centre for Tax Law. He says the financial information coming out of these companies is minimal, and part of that is New Zealand's fault.
There has been now quite a long history of less and less information and less demanded from them. When I think back slightly more than a decade ago, all overseas owned companies had to provide audited accounts to the Companies Office, but that was abolished, and so they can operate pretty much below the radar apart from this type of investigative approach.
Why was that abolished? Is this part of New Zealand making itself easy to do business in?
That's it. Yep, you've got it in one. It was just a complete focus on let's take the cost out of multinationals' playbook.
I mean, it has put us at number 2 in the list of countries in the world that are easy to do business, but we're paying a big cost for that statistic.
I think particularly in this area, we're not alone. It's been masterfully played, I think, by the US in particular. It's almost like they consulted and procrastinated, and now, after more than a decade of reforms, are now just completely ignoring requests from around the world and offering instead, anything that hints at not being in their interests is likely to be punished with these tariffs.
Is New Zealand politicians, New Zealand Tax Department intimidated by this sort of retaliatory threat hanging over these companies?
Well, they wouldn't be alone. I think there is a great deal of sensitivity to the trade consequences. I think tax and trade are sort of been joined up at the hip, so that it is very, very difficult. And, like the European Union is another good example of a much stronger bloc of countries that are being forced into suspending or eliminating their digital taxes, which is one of the mechanisms to counter this.
There have been international moves to try and rope in these huge companies, but as you'd expect, it's been really hard to get everyone to agree on reforms. Last year, we got political agreement among countries on several strands of attack. There was a Pillar 1 and a Pillar 2. Here's the guts of it from a Deloitte expert.
One of the first things that was agreed was that for the very largest multinationals globally, approximately the largest 100 companies, 25% of residual profit will be allocated to market countries. So essentially allocated to countries where the business makes sales or has users. So alongside that, for large multinationals with turnover of more than 750 million euros, there's also going to be a global minimum tax rate of 15% in every country where they do business.
Pillar 1 has definitely fallen over, and we're just waiting for the coronial report. The Pillar 2, though, is still on life support. The US have said that they will not participate in it, but they have got an agreement whereby their own domestic version of a minimum tax could sit alongside the Pillar 2 that the rest of the world has to comply with. But it's yet to be seen whether there are other major countries like China, for instance, might say, well, if it's good enough for the Americans not to do it, we'll just not be part of it either. So we'll see what happens. But those two major areas of reform, which have, everyone spent a lot of time and effort and huge number of meetings in Paris and all those sorts of things have happened, all with a very constructive idea of trying to work together to make these very large global companies pay the correct amount of tax in jurisdictions where they do business.
And one of the other tactics of these big companies is when they are hauled over the coals by a country's tax department or, action is taken against them, they just tie it up in court for years.
Yeah, totally a mixture of that, and plus also to get settlements whereby the revenue authorities in the particular jurisdiction have made a win of some sort, but it's of course not necessarily reflective of, it's a concession. And most importantly, and it's the bit that New Zealand struggles with quite a bit, is that we aren't a jurisdiction that's very high up in terms of significance or importance from the multinationals' perspective, but the outcome, the result, could have an impact of an adverse settlement for the company. Could have a significant problem for that company as a precedential effect on the rest of the world.
Basically, if they give in to New Zealand, we get a win out of them. Other countries will be looking at that and thinking we can do that too.
That's it. Yeah. So we can be a sort of little test market, really, in a way. The Australians have been leading the way, as the report highlights. They are pretty aggressive on some of the issues, particularly to do with royalties.
Well, yes, and Nick's report suggests this way of defining the sort of service fees that these big companies pay, and I want to say that in inverted commas, to their headquarters, as royalties, and therefore extracting a perfectly legal and existing in current legislation tax on them, a 5% tax on them, which in itself would raise billions. Why don't we do that?
I think the answer is that we may. The Australians have taken a couple of cases which have, the latest one has just played out with a judgment just delivered last month for Pepsi.
And the tax office had a big loss in front of the full bench of the federal court today. This relates to the way PepsiCo, one of the world's biggest food companies, was paid for the syrup that makes Pepsi here in Australia. Now, Pepsi doesn't make its own soft drinks in Australia. It has a deal with Schweppes. So the court had to decide whether withholding tax should be applied to embedded royalties for the Pepsi brand and intellectual property. The federal court ruled in favour of the tax office, but the appeal to the full bench was upheld. Pepsi won. It's not liable to royalty withholding tax.
Basically, local bottlers paid Pepsi HQ a massive amount for the magic goo that makes Pepsi Pepsi. Australian authorities believed the amount was too much for just syrup, and hidden in the fee was a payment for the brand's intellectual property, which would be subject to a royalties tax. It was a narrow loss. The High Court judges were split 4-3. with suggestions that the tax commissioner hadn't prepared the case well enough.
It's a little hard to understand that, quite frankly, for the ordinary person, because the value of, Joe's Cola versus Pepsi is quite different, and there is clearly an intellectual property element to the brand of Pepsi, which makes a significant difference to its price. There's another factor that New Zealand has actually very strong case law on anti-avoidance provisions, and the particular provisions in New Zealand, same as Australia, have an anti-avoidance flavour to them. And so the particular definition of what is a royalty, it was firstly driven by a case when they introduced it back in the 1930s, I think. It was a provision created because there was a problem, and they wanted specifically to be able to dissect the purchase price into components of royalties or otherwise. So there is a history there.
Right. So we could enact this fairly painlessly by saying to these big companies, we understand actually that in spite of what you call it, that's a royalty payment. Hand over your 5%, please.
Well, it's untested, but there is definitely the possibility of a case not only being taken, but actually being successfully taken in the New Zealand courts. So I think it's actually a stronger position, if you like, based on New Zealand case law and the New Zealand judiciary. It's probably stronger than it is in the High Court of Australia.
When Nick Miller's report came out, as a tax lawyer, what were your reactions?
I thought it was a very good summary of a series of factors which drew together and make quite an accurate picture of the problem. I don't know about the numbers and the quantum, and it may be that he is overstating the amount of tax, but nonetheless lays bare the extent of the problem. And so it's a very helpful report.
I mean, politically, why isn't this factored into our budgets? Why doesn't Nicola Willis say, let's pay for that hospital by making Apple and Google, whatever, pay their fair share of tax?
Well, I think we return to the question that the whole world has been struggling with a little bit. And, I think various governments over the last decade have been looking for that multilateral solution, the Pillar 1, Pillar 2, and now this has fallen over. It's particularly fallen over with the current president being very aggressive and very firm in the approach on tariffs. So I can understand that you don't want to raise your head above the parapet.
Does it frustrate you that while Joe Blow on minimum wage is paying their fair share of tax, that these guys aren't?
That's a hard fact, actually, that you do have the largest companies in the world who have, I think maybe it's always been this way, but it's just difficult to reconcile. We're very good at collecting tax from medium and little people, and we're not actually really all that good at taxing
the big fish.
Yeah, both individuals and even more so multinationals. Yeah.
That's it for today. The Detail is a newsroom production supported by RNZ and New Zealand On Air. This episode was engineered by Alex Harmer and produced by Gwen McClure. Thanks to Nick Miller and Craig Elliff. I'm Alexia Russell. Ka kite anō.